In a stunning legal setback for the UK government, the Court of Appeal has refused to block a challenge against the controversial ban on Palestine Action under terrorism laws. This decision opens the door for a High Court judge to review the ban as early as next month, a move that could have far-reaching implications for free speech and protest rights. But here's where it gets controversial. While the government argues the group poses a threat to national security, critics claim the ban is an overreach of power aimed at silencing legitimate activism. And this is the part most people miss. Over 2,100 individuals have been arrested since the ban took effect, with 170 facing charges that could land them in jail for up to 6 months, all for allegedly supporting a group they believe is fighting for justice. The saga began when Huda Ammori, co-founder of Palestine Action, secured permission earlier this year for a judicial review of the Home Secretary's decision to ban the group. The government, however, fought back, arguing that the proper avenue for appeal was through a lengthy internal review process overseen by the Home Office, a route that could take over a year. Here's the kicker. Ammori's legal team countered that this process was inherently unfair. Given the group's unique circumstances and widespread public support, they argued that Parliament never explicitly ruled out a faster, more direct challenge to the ban. In a bold ruling, Baroness Sue Carr, the Lady Chief Justice, sided with Ammori, stating that the initial decision to ban Palestine Action could be challenged immediately through judicial review, rather than waiting for the slower, semi-secret Prescribed Organisations Appeal Commission (POAC) process. Judicial review, she noted, would enable the High Court to deliver an authoritative judgment on the lawfulness of the ban, a judgment that could then be relied upon in criminal courts. The Home Office, while acknowledging the ruling, doubled down on its stance. Palestine Action remains a proscribed group, a spokesperson stated. Those who support them will face the full force of the law. Supporting Palestine and supporting a proscribed terrorist group are not the same thing. But is this distinction clear-cut? Critics argue that the government's definition of terrorism is being weaponized to stifle dissent, particularly when protesters holding signs like "I oppose genocide," "I support Palestine Action," are being criminalized. Ammori, meanwhile, celebrated the ruling as a spectacular backfire for the government. We now head into the judicial review in November with an even stronger legal footing, she declared. She also highlighted the broader issue. Arresting peaceful protesters and those disrupting the arms trade is a dangerous misuse of counter-terror resources. Here's the question that lingers. Is the government's ban on Palestine Action a necessary measure to protect national security? Or is it an attempt to silence a movement that challenges its policies? And what does this mean for the future of protest rights in the UK? Let's discuss. Do you think the ban is justified, or is it an overreach of power? Share your thoughts in the comments below.